for 5 and 6.
How you doing? It's been a while.
Mr. Findling?
Sure.
The court has called the case of Karen Lynn King to trial as per special setting last week. The state is now not ready due to a witness problem.
And Your Honor, if I could put this in context for the court, on Thursday, August 31st, Ms. Simpson, the case manager, contacted me. I was actually in front of Judge Russell at the time, reached out so that we can come along with Mr. Ingram. He was in here. In fact, no, Mr. Ingram reached out to me and said that Ms. Simpson would like to specially set the case if I can come by. So as soon as Ms. Goldberg and I were done with our hearing in that matter, we came up and along with Mr. Ingram, we met with Ms. Simpson and we specially set the case for Monday, October 2nd, after reviewing the calendar that worked out for both the state and the defense. On Monday, September 25th, Ms. Simpson, on behalf of Your Honor, summoned us to come here just to make sure that everything was set. I was at the calendar. We were called. We announced ready at that time. I think the state announced ready. And you actually asked me to come here at 9 o'clock. And you asked me if we had any motions. I said 15 minutes probably worth of motions. Other than that, we'd be ready to go. So we were, as Your Honor said, specially set to commence. On Tuesday, September 26th, at 10:55, I received an email. From Mr. Ingram that said, "I'm meeting with my boss this afternoon about the trial. I'm sure the question will come up as to what you're asking for. The context of this will make sense in a second. It is my understanding that the defense is asking for a dismissal because on that Monday, the 25th, I said, hey, we really want this case to be dismissed. We set us 6 months. Ms. King doesn't do anything wrong, just dismiss the case. And that was his response to that. So he said, it is my understanding that the defense is asking for dismissal. I think that pretty much assures us that we will go to trial. Now, this is the Tuesday before a specially set Monday, 9 a.m. jury trial. Let me know what, if anything, she is willing to take so that I can present it to her during the meeting. I'm not making any promises, of course, but I would like to avoid meeting with her multiple times. If there's any chance of resolution short of trial, please CC Mr. Rao. Either he or I will be first chair on the case. I'm transitioning to CWAC at the moment, and he acknowledged that I have his cell number."
That's not an unusual communication between defense counsel.
Absolutely not. And that's why I said it kind of brings into context because of what we're hearing is the reason for this continuance. And by the way, that 6 days out and 7 days out, nobody ever said anything to you about a witness being unavailable for medical reasons, which is important.
Well, I did hear something,
Yes.
something on Tuesday.
Okay, all right.
To Bonnie Willis, the supervisor for Mr. Ingram.
Okay, and we're going to talk about ex parte communication in a second because there may...
I didn't talk to you.
Not you. Not you, Your Honor. But no, I know that. But there's a little bit of a comfort level where people think they can reach out to court personnel without including the other side on a specially set trial, which I take umbrage with on a specially set case. Now, the reason why that is of importance is that on Wednesday, and then there was, after that, there was attempts to talk, emailing back and forth, no firm conversation on the 26th. On the 27th, we did talk to Ms. Willis. And Ms. Willis had we had a couple of telephone conversations with her, and at that time, she talked about proposing a resolution. She talked about who my client was. My client may have the ability to speak to people in the community, and maybe some good can come out of this case. And just without even getting to the specifics of that, she then told me that, to be honest with me, I can communicate this to my client. She had a couple problems with the alleged victim in the case. Two, one, that the victim, the alleged victim, had been online, read about my client, an old case of hers, and was scared to come down here. One, that was one. Two, she had not traveled since September 9/11/2001, had not air traveled since then, to which Ms. Willis said, if I have to, I will send somebody in a vehicle from our office to drive her down here for trial. And so those were the two factors that were presented to me, and Ms. Willis, who I've had plenty dealings with and has always been straightforward with me, said, you can communicate that to Ms. King. I want to be honest, transparent. Let her know that's part of my motivation in bringing a resolution in the case. Not once on a specially set trial on the Wednesday before that 9 a.m. trial did anybody say anything about any physical issues. We talked towards the end of the day, and I gave some specifics that I will do without cameras here about the nature of those conversations. I think it's inappropriate to talk about negotiations in this setting, but we had multiple conversations, and Ms. Willis said on late Wednesday, at the end of the day, let's sleep on it, was her exact quote, and talk tomorrow. I did not hear from Ms. Willis on that Thursday. At that point in time, Franklin Ingram sent a text message to Ms. Goldberg in my office that he had not seen Ms. Willis, didn't know if she was in on that Thursday, but had not seen her that day. He reaffirmed that position early on Friday. And the conversations continued. I will tell the court that I received an email that was disconcerting to me. At 11:48, I received an email from Ms. Simpson that listed the cases and said, Karen King, only if it's a plea. Now, I know that I've dealt with Ms. Simpson. She's just on this year. And I got alarmed by that. Now, during this whole thing, we're hearing about the switching up of counsel, and that Mr. Ingram is switching to CWAC, and that Mr. Rao is taking over, all of which I don't really care about. Not my business, how anybody runs their office. All I care about is I have a specially set trial with a bunch of people coming in to watch the trial, to support their loved one and their friend and their family member. That's all I cared about. So during the course of these conversations, emails come across. At 11:58, we hear from, at 11:58, mind you, 10 minutes after the email from Ms. Simpson that said only to report if it's a plea, 10 minutes later, we receive an email from Mr. Ingram saying, I'm not going to continue negotiating like this. If we do not agree on the curfew, we will continue to get ready for trial. No mention about this new thing about somebody being ill and can't be here. So I will tell you, in retrospect, and at the time, I'm getting this feeling like I'm being played right now. Somebody is telling Ms. Simpson, we're not going to trial, but trying to squeeze me to get Ms. King to take a deal. So I'm getting a little uneasy what's going on here, okay? Because I do keep up with my ethics credits, and I do keep up with my professionalism credits, and I'm thinking, maybe somebody else isn't keeping up with their ethics credits and their professionalism credits, and they're trying to put the full court press on me. And Your Honor's known me back to the PD days, 30 years of fighting battles. I have as many prosecutor friends as I do defense friends, but I don't like the game. And I don't like when somebody's constitutional rights are being toyed with, and I could feel that coming. So we continue to have conversations. There's there's an attempt to get us to bring a resolution to the case. And at 4:15 is really the first time I'm speaking to Mr. Rao, right? Because he's new in the game. And so we're talking about possible resolution. And I tell Mr. Rao, I said, Hey, I got a question that I need to ask you. I'm a little confused by this 11:48 email from Ms. Simpson about only if it's a plea, to which Mr. And I get that he's new in the case, and again, with respect to him, I can care less that he's new in the case, okay? To which he tells me that, oh yeah, Ms. King only needs to show up if there's going to be a plea. I'm like, no, this is especially set. Number one, I would never do that and have her locked up. We've learned that in this case before, okay? So I'd never do that. And number two, hey man, I don't know what you're talking about. To which he said, oh, our client, our alleged victim had hip surgery. I'd never heard this one before. To which I let him know, first of all, there can't be communication with Ms. Simpson without me being present.
Well, on scheduling matters, it's not uncommon for Ms. Simpson to speak to the DA. She has an awful lot of cases to schedule, and we probably do not communicate with all defense counsel as to scheduling matters. So.
And Your Honor, she's fantastic, and this is not one of the hundreds of cases. This is a case on the Friday before a specially set jury calendar, okay? And so I think this becomes a little bit different. I get that. I've been in this system a long time, but when a case is getting ready to crank up, when you're hours away from cranking up, you need to let the other side know.
Could I short circuit a little
Yeah.
bit and just ask a question? You ready for trial?
We're ready for trial.
What's at stake?
Your Honor, like I said before, our witness is in Connecticut. She is 70 years old. She is recovering from hip surgery. She's in fact hired an attorney after we had Your Honor sign an out-of-state witness packet where we had an inspector from the police department at that location go and talk to her. She became frightened because she thought we were going to arrest her for not being able to show up to court because of her hip surgery. So after that, we told, and we spoke to both Mr. Ingram and I spoke to that attorney. He said that is in the process of getting us a doctor's note and getting us an availability date for this witness to come down and testify.
All right.
And my response to that is that there are three relevant statutes, 17-822, 17-825, 24-13, okay.
Just let me say something.
Okay, sure.
I'm going to call the case for trial. So you can try the case or you can not process it.
Yes, sir.
Today's trial date. This case was allegedly occurred well over 2 years ago. It was indicted well over 2 years ago. It's been special set, it's been called for trial. So you can select a jury today, or you can null process and have 6 months to refile if that's what you'd like to do.
Yes, sir.
What's your option?
Your Honor, we will, at this time, if this case is being called out today, we will not process this case and bring a new indictment within 6 months.
Ms. King, the charges against you are dismissed at this time. The state has 6 months by law to refile charges. Please stay in touch with Mr. Findling.
Thank you, Your Honor. Will you be excused?
Yes, sir.
If I could, Judge, if I could see Mr. Findling and Mr. Ralph, please. Because some stuff was misrepresented to the court, and we don't have to be on record. So the conversation will yeah, let's do that.
All right.
Got it. Miss Carey.
Ms. King, feel free to go.
Free to go.
Counsel, Ms. Gold?
Yes, let's go back to the table. Oh, okay.